Thank you, Speaker. On behalf of the Joint Standing Committee on Treaties, I present the committee's report entitled Report 206, International Labour Organisation's Convention concerning minimum age for admission to employment, and I ask leave of the House to make a short statement in connection with the report.
Is leave granted? Member for Herbert.
Leave's granted.
Leave is granted. Call the member for Fremantle.
Thank you, Speaker. I'm glad to make a statement on the Joint Standing Committee on Treaties report into the International Labour Organisation Convention concerning minimum age for admission to employment. The purpose of the convention is to effectively advance the abolition of child labour, to see it abolished the world over. Child labour, by definition, means improper, unacceptable, harmful forms of work by children, and the abolition of child labour is to be achieved by protecting the right of children to attend school, by regulating the types of economic activity that may be undertaken by children, and by ensuring that children's health, safety and morals will be protected. The Convention contains three key obligations. Members that ratify are to specify the age of completion of compulsory schooling, which in any case shall be not less than 15 years of age, as the minimum age for admission to employment. They are to establish 18 years as the minimum age for hazardous work, or 16 years where certain protections are in place, and, where permitted by national laws, specify the conditions for children no younger than 13 years to undertake light work. Speaker, while there is no Commonwealth legislation governing the minimum age for employment or work in Australia, and while practices across jurisdictions differ, it is nevertheless the case that state and territory legislation governing school attendance in effect sets 15 years as the minimum age for employment or work. And although Australian law does not specifically preclude a person under the age of 16 from engaging in hazardous work, the committee was made aware of a combination of workplace health and safety laws, compulsory schooling requirements and sector-specific regulations that effectively limit its occurrence in most fundamental respects. Like other international labour organisation conventions, this agreement provides flexibility mechanisms to accommodate the differing legal systems of members. Australia plans to rely on one such mechanism, Article 4, to exclude from the application of the Convention limited categories of work. These would be categories that allow children under 13 years to undertake light work like delivering newspapers or pamphlets, or work in a family enterprise like a farm or a market stall, either because it's permitted by existing state and territory legislation, Deputy Speaker, or because the type of work occurs in practice and the available evidence suggests to us that such work is undertaken in beneficial circumstances without impact on the health and well-being of children. It is worth noting that Australia has not exactly moved swiftly to ratify this convention and will in fact be the 176th country to do so. Considering that we exist in a region where relatively few nations have ratified the convention, where preventing child labour is a relevant challenge, Australia's ratification will strengthen our credibility when it comes to promoting strong measures to eliminate child labour in the Asia-Pacific. For all those reasons, the committee supports the convention and has recommended that binding treaty action be taken. I thank the Deputy Chair and our fellow committee members, and of course the Secretariat, for their work on this inquiry. And Deputy Speaker, on behalf of the committee, I commend this report to the House.